In our October client update, we provide detailed information about the investigations, class action lawsuits and criminal proceedings relating to the companies we report on and or whose claims we represent. We will start with the current events with respect of Hubert Friedel and responsible Lynas, Lyconet and Myworld group of companies. The insolvency administrators of Lyconet and Myworld are currently sending letters to marketers asking creditors to register their claims. We would like to point out that our customers do not need to take any action. Since the 1st of September 2025, it has been officially confirmed that the insolvency estate of Myworld International AG is insufficient to satisfy the claims. The insolvency administrators are now pursuing Lyconet's highest paid top leaders in order to reclaim commissions from the last 10 years. Our customers are deliberately not part of the Myworld International insolvency proceedings. Their claims will be asserted in separate proceedings, as we had anticipated and repeatedly announced this development and the bankruptcy. As the circumstances have changed completely due to the insolvency of the companies, we will file a lawsuit on behalf of our clients before the Vienna courts for future customers to hold the defendants jointly and severally liable for damages and to determine their liability. Our legal review has revealed concrete evidence of personal liability on the part of several executives, including Hubert Friedel, founder and de facto decision maker; Zeniq Friedel, international communications and marketing; Marko Sedovnik, CEO of Myworld International AG; Monica Mararova, authorised signatory; and Mario Capun, sales manager. We will deal with Sharif Omar separately, especially since he was appointed to the supervisory board of Myworld International immediately before the insolvency, namely on the 29th of July 2025. The legal basis for the lawsuit is number 1, corporate liability under sections 25 of the GmbHG and section 84 of the AKTG, meaning breach of duty due to late filing of insolvency. Number 2, tortious liability under section 1295 in conjunction with section 1301 ABGB, collective action to mislead investors. Number 3, fraudulent misrepresentation under section 870 of the ABGD and analogously concealment of the risk of insolvency despite a security order. We would like to emphasise once again that the insolvency has no influence on your submitted claim. As we expected and often predicted, we have completely repositioned the insolvency for you from a legal perspective and are dealing with the individuals directly. On the 7th of October, a review hearing on the bankruptcy proceedings against Myworld International AG and Myworld Austria GmbH took place at the Regional Court in Graz, Austria. If you are wondering what an Austrian limited company has to do with you, all international commission payments were paid out via Myworld Austria GmbH. These proceedings are public, and we were there on the 7th of October. Only the creditors of 3/1-3/146 were dealt with under file numbers 27S130/25G and 27S129/25K. This concerned the current status of who had registered, how much money and how much was still available. We will publish a comprehensive report on the figures and data in a separate article. A second examination hearing has been scheduled for the 27th of January 2026 at the Graz Regional Court, and we will be there for you. Scheduled dates at a glance are for Myworld International AG, LGZ Graz of 638, file number 27S129/25K. The date will be the 27th of January 2026 at 9:30 a.m. The location will be room number 230 of the second floor, Hall L, Regional Court of ZRS Graz, Marburger Kai, 498001 Graz. And for Myworld Austria GmbH, the date will be the 27th of January 2026 at 10 a.m. with the location room number, again, 230 on the second floor, Hall L, Regional Court for ZRS Graz, Marburger Kai, 498001 Graz. We have important information about block trade under the FSR group and the uncertainty for e-credits investors. From the documents we have in our possession and research into the change of ownership and subsequent restructuring of block trade, we have gathered several pieces of evidence that suggest a plausible scenario of concealment of sales proceeds. Upon examination, we have established a connection between players from the Lyconet Myworld environment and block trade. The name Mario Oregia appears in the relevant documents. The chain, shopping points, e-credits, block trade makes it plausible that MLM structures were integrated into the capital flows. The block trade sale was apparently conducted as a share deal. Proceeds from such a transaction flow to the sellers and do not appear on block trade's balance sheet, but only at the level of the sellers. This makes it difficult for outsiders to understand how much money was actually moved. In addition, the Estonian operating company Block Trade Operations OU has not submitted any annual financial statements for 2023 and 2024. This is precisely where traces of capital inflows or other movements would normally be visible. At the same time, the structure was relocated. While Estonia was burdened with tax debts and missing reports, a Slovenian branch suddenly moved into the spotlight. This branch is not a separate legal entity, but it creates a break in supervision and increases opacity. It is also striking that Web3 Invesco AG, which was involved, is now being liquidated. This means that detailed payment records and distribution lists are disappearing into liquidation files that are difficult for third parties to access. We also consider it obvious that payments were concealed through alternative channels such as loans, consulting contracts, license fees, or distributions to private individuals. In this way, sums could be fragmented and moved across borders without outsiders being able to identify clear payment flows. This scenario seems plausible and explains why the specific sale amount cannot be traced so far. This gives reason for us to file a criminal complaint. Block trade investors can now contact us to lodge claims pursuant to the successful recovery of investments. Secure your own documents. Our solicitors are preparing a comprehensive lawsuit against block trade and those responsible. There are sufficient and conclusive grounds for legal action. We will now turn our attention to Karatbars, Apertum, DA01 and affiliated companies and persons. On the 2nd of October 2025, the BaFin, meaning the Federal Financial Supervisory Authority in Germany, officially warned against DA01 and the offers of Apertum Holding Limited. The authority classifies the crypto trading services advertised via iBots as unauthorized and expressively advises investors to exercise caution. It highlights a recurring pattern: technological exaggerated promises, aggressive marketing via webinars and social media, and targeted solicitation of small investors. The BAFIN thus joins a series of international supervisory measures, including those taken by the FMA in New Zealand, ASIC in Australia, and the Texas State Securities Board. It is important to know that the lifting of the Texas emergency order is not an acquittal and does not constitute a finding of substantive legality of the products. DA01 is therefore not automatically out of the authority's focus. At the time, warnings from other supervisory authorities, example the BAFIN, ASIC and the FMA, remain in place. Investors should view the PR presentation of an acquittal with caution, as it does not correspond to the official legal situation. We are in contact with the authorities and international law firms and are vigorously supporting victims in their action against the so-called MLM empire surrounding Joseph Haidt. We can announce that we have conducted extensive research into Joseph Haidt's assets, which we will publish on our website and social media channels in the near future. Apertum Holding Limited and Joseph Haidt have repeatedly and unsuccessfully taken legal action against our thoroughly researched articles, which spurs us on even more to take up the cause. We will now focus our attention on Safir, Zeniq, X-Pro, Omnify, etc. The proceedings against Zeniq were discontinued on the 10th of March of 2025 due to insufficient suspicion of a crime pursuant to Section 190 of the German Code of Criminal Procedure. However, this dismissal is not legally binding, as an appeal has been lodged against it. The appeal contains new and additional evidence which is currently being examined by the Public Prosecutor's Office. Through our lawyers, we have already prepared and filed class action lawsuits against the company and individual responsible parties. In our opinion, this very extensive and time-consuming preparatory work has the best chance of success in both criminal and civil law. In order to classify the current developments and present the background transparently, we will conduct an exclusive interview dealing with the Safir, Zeniq, X-Pro, Omnify projects and other related structures. I am often asked what are my views on cryptocurrencies, and in particular in MLM or unlawful pyramid and Ponzi schemes. Let me begin with a brief outline of cryptocurrency. Admittedly, at the risk of oversimplification, given that there exists thousands of different cryptocurrencies on the open market outside of MLM schemes. At its simplest, cryptocurrency is created from code. It can be used to make payments and does not exist physically in the form of notes or coins. It is created using blockchain technology, a blockchain being a ledger method for recording transactions. There are many cryptocurrencies in the global market. Many of them carry a great deal of sale, but very little ballast. Cryptocurrencies in MLM schemes basically have no value, and they don't produce anything. So you can look at your ledger and it says you have X amount of this cryptocurrency, but it doesn't reproduce or deliver a return. It has no utility and it can't do anything. And what you hope is that you can find somebody else who comes along and pays you more money, and that person carries the problem forward. When you invest, you need to be certain that the company you are investing with is a bona fide registered company and holds the respective credit and financial services licenses. If any real investment exists, the company should also publish a timely financial prospectus. If there is an affiliate or network marketing scheme involved, your investment will lose anything up to 70% the moment you pay into the scheme, which is paid in upline commissions. And if no real investment exists, these schemes are generally found to be unlawful, pyramid or Ponzi schemes, or a combination of both. Cryptocurrency pyramid and Ponzi scheme promoters target vulnerable consumers and want you to exchange real currency for fictitious cryptocurrency and or tokens, and attempt to induce victims into believing that their cryptocurrencies will supersede fiat currency and the banking sector as we know it will be replaced. In essence, the perpetrators of such schemes exchange your real currency, and in return you receive worthless data on a back office ledger. Broadly, the only real currency is that which is accepted in trade and commerce and holds value, such as the Australian dollar, US dollar, Japanese yen, the euro, and the British pound sterling, etc. In terms of unlawful pyramid and Ponzi schemes, these cryptocurrencies lose value upon entry and are basically worthless. We should always conserve good things when worse things are proposed to be put in their place. Our slogan, "Together instead of alone," benefit from our association and assignment proceedings without high individual costs.